Is the right to energy the way to end energy poverty? Before trying to provide some elements of answer to this question in light of the Greek experience, allow me a disclaimer. My thoughts will be mostly delineated by my capacity as what could be possibly called an international human rights law generalist. Well, given this capacity, it would be unlikely for me to maintain that the right to energy wouldn't be a way to end poverty energy. Using human rights conceptualization is a potent rhetoric tool to shape public debate and raise awareness. Furthermore, the international human rights institutional machinery is an efficient framework for addressing energy poverty. Would the right to energy as such be the only way to end energy poverty? Yes and no. This is a question open to debate, and it might be that I am biased because in 2021 I still mostly regret the inefficient implementation of existing rights rather than contemplate the generation of new ones. Allow me to illustrate these points by referring to specific cases from the Greek context. I will address in particular the most representative cases decided by Greek courts with respect to electricity, scrutinizing them through the lens of human rights. In this context, the human rights implications of the financial crisis will by necessity be alluded to, and parallels will be made with the right of water. The most important, the most pertinent to our topic cases related to legislation adopted in 2011 during the Greek financial crisis in the context of what we call austerity measures. The first set of cases pertain to the so-called electricity bill levy, and the most recent case I will refer to pertains to the electricity supplier switching. First, the electricity bill levy cases. The special levy introduced in 2011 was calculated based on each person's residence, and the particularity was that it was attached to the electricity bill. This implied that a failure to pay the special levy resulted in cutting off of electricity, inability to request reconnection until the special levy had been paid in full, and inability to sign a contract with any other electricity provider. Both Supreme Courts of Greece, the Council of State, that is the Supreme Administrative Court, and Arios Pagos, the Supreme Civil and Criminal Court, delivered judgments on the compatibility of this measure with the Greek Constitution. Two issues were at stake. First, the compatibility of the measure with the right to property, and second, the possibility of the Public Power Corporation to interrupt the power supply. With respect to the first issue, whether the measures were compatible with the right of property, the Council of State, the Supreme Administrative Court that is, was the first to pronounce a judgment on the matter in 2012. It found that the law was constitutional, and it did not violate Article 1 of the additional Protocol 1 to the ECHR. Let me remind you that Greece is a monist state. That article was about the right to property. The Council of State was of the opinion that due to the financial crisis, the state was well within its power to adopt such a law, as it would serve the public interest, an exception, after all, provided in Article 1 of Additional Protocol 1 to the CHR. Consequently, the law was a legitimate restriction of the right to property. This is also what Arios Pagos, the plenary of Arios Pagos, finally held in 2016. I say finally because in 2014, the fourth section of the same court held that the measure implied a disproportionate burden for the Greek population that has already suffered from the successive reduction in wages and pensions, and the simultaneous maintenance of commodity prices at high levels, the increase in real estate fair values, and all this resulted in the reduction in the purchasing power of citizens to a point that a significant number of them were unable to ensure even the minimum standards of decent living. At that point, Arius Pavos even referred to Articles 2 and 21 of the Hellenic Constitution on the respect and protection of the value of the human being and the protection of family accordingly. Now, the second issue had to do with respect to the electricity levy, had to do with the possibility of public power corporation to interrupt the power supply. Always in 2012, the Council of State declared that the possibility of the Public Power Corporation to interrupt the power supply constitutes a constitutionally impermissible interference in the contractual relationship between the consumer and the electricity supplier, which is in breach of Article 5, Paragraph 1 of the Hellenic Constitution on the economic freedom and freedom of contract, and the principle of proportionality, as it leads to an infringement of the universality of providing a network of public utility services for a reason which is not related to the provision of that service. Such a finding is important on its own. However, I'm tempted to praise the separate opinions of a series of judges that also linked the measure at hand to the violation of Article 2 of the Constitution on the respect and protection of the value of the human being. According to this view, the deprivation of access to electricity was equivalent to a deprivation of a social good of vital importance, essential to the dignified, under modern standards, living of the individual. More recently, in 2020, the Council of State found incompatible with the Greek Constitution the prohibition of electricity suppliers switching in case of unpaid overdue debts to an electricity supplier. It invoked in particular the principle of proportionality, as less restrictive measures were available to fulfill the same end, and Article 5 of the Constitution that stipulates that all persons shall have the right to develop freely their personality. Now, what is the takeaway of the Greek experience, which was briefly presented here? Even though such an assessment would require a thorough elaboration on the institutional particularities of the Greek context, which is impossible here, I will nonetheless allow myself the margin for a couple of observations. Pragmatically, it seems that the Greek courts came up to the expectations of the circumstances during the Greek crisis and issued judgments that, at least to a certain extent, protected some of the aspects of what we call the right to energy. Electrical disconnection, because of not paying a levy, goes against the universality of providing a network of public utility services. However, one would have expected a more decisive approach on the human rights dimension of the cases, with the acknowledgement of the connection between electricity and highest attainable standards of living, or other rights enshrined in the Constitution, especially at a time of crisis in which the austerity measures led to the pauperization of a significant segment of the population. The right to health could have been one of them. After all, the Council of State did refer to it with respect to the right to water in 2014. At least what we call right to water in international human rights law. There are more cases pending right now before the plenary of the Council of State, but I will refer to the Greek Council of State case of 2014, where the court held that issued a ruling prohibiting the sale of majority shareholding in the water supply and sanitation companies of Athens and Thessaloniki on the grounds that that it would create uncertainty regarding the continued provision of affordable public services, referring also to the right to health protection and the state's obligation to uphold public health standards. To make justice to the Greek case, though, it is important to refer to one more case pertinent to energy poverty by implication. The Council of State was more meticulous with respect to human rights, at least this is my take on it, at a later stage in 2015 with respect to measures curtailing pensions. The court referred to heating among other necessary commodities. It held that the cut in pensions cannot violate the social security right, the provision that is to the pensioner of benefits that will allow him or her to live with dignity, ensuring the conditions not only of his or her physical condition, but also of his or her participation in social life. Now, with respect to physical condition, the court explicitly referred to heating. It listed food, clothing, housing, basic household goods, heating, health, and medical care of all levels. Very importantly also, the court suggested that the state should undertake a human rights compatibility evaluation prior to the adoption of financial measures that would possibly infringe upon these rights, a process similar to what we call in international human rights law human rights impact assessment. If I'm allowed to comment, this rule also demonstrates that during the Greek crisis, the right to energy was not independently advocated because the situation was so dire that any call for advocacy had to be as global as possible to cover all the necessary commodities. I was working back then as a legal officer for the Greek National Human Rights Institution, and my take on the matter was that bringing social and economic rights in the forefront was on its own a fight. Let us not forget that still in 2021, human rights debate is not deprived of this division between rights. Now, what are the best ways to pursue the right to energy or address in practice energy poverty? Well, the tools to address energy poverty are there in the human rights law arsenal, with or without the development of an independent right to energy. It is our responsibility to make them work. Who is us? Every social and institutional power within a state, the executive, legislative, and other policymakers, the judiciary, civil society, academics, citizens, everyone. Thank you for your attention.